Will the court reporter please swear in the witness?
Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning, ma'am. Can you please state and spell your full name?
Karen Wagner, Carynwagner.
Where are you currently employed?
Department of Child Safety?
That's the state of Arizona.
Yes.
How long have you been employed there?
About 5.5 years.
So what's that, like 2009?
No, I'm sorry. 2011.
Did you have any supervisory responsibilities as a investigator level 4?
Occasionally.
Okay, describe for me what that would entail. Supervising who, supervising them doing what, that sort of thing.
It would be if my supervisor was out for the day, I would cover, help staff cases, help assign cases, and review court reports.
Did you, as part of this reviewing the court reports, did you have any responsibility to ensure the accuracy of the statements that the social worker was inserting into the report? Sorry, your answer was?
Yes.
And explain to me, if you would, how would you go about when you're reviewing one of these reports that a different investigator wrote? How would you go about ensuring that the statements that investigator inserted into that court report were, in fact, accurate?
When you file a petition with the courts, you file a petition with allegations on there, and then you sign an affidavit. And so I would review their petition and make sure that those allegations that were in the petition is in the court report.
Okay, and correct me if I'm wrong, but you said they sign an affidavit along with the petition?
Once it's submitted to the Attorney General's office, they send it back for accuracy, and that worker is responsible to sign a verification saying the information is correct and accurate.
Okay. And then as the supervisor or in a supervisory capacity, when you're reviewing one of these reports for accuracy, correct me if I'm wrong, but as I understand it, you go back and you look at the allegations in the petition and then look at the affidavit to make sure it's there and it's signed.
Yes.
Is that all you do to ensure that the statements the investigator puts in her court report are accurate?
I also review their documentation in the case notes. It's called a CSRA.
Okay, explain to me a little bit about that. What do you mean when you say you review their documentation in the case notes, the CSRA?
It's called a child safety review. It's the format in which we document the events of the case.
When you say we document the events of the case in this, that's in the CSRA, right?
Mm-hmm. Yes.
The CSRA, correct me if I'm wrong, but that's some sort of computerized database or something?
Yes.
Okay, and essentially the investigative worker will sit down in front of a computer somewhere or a terminal screen and then enter her data or his data into the CSRA system?
Yes.
So like investigative notes, those sorts of things?
Yes.
Okay. And when you say you go in and review the investigator's case notes in CSRA, that's what we're talking about, right? Would be the data that that particular investigator inserted into the system relative to their investigation.
Yes.
Do you do anything to ensure that the data that investigator put in the system is true?
No.
So when we're looking at the data in the CSRA in the context of reviewing these court reports for accuracy, you essentially just take whatever the investigator put in the system at face value.
No.
Okay. What do you do besides read the case notes to ensure that what's actually there, the data you're reading, is true and accurate and complete?
I mostly go off of what the petition says, what the allegations are in the petition.
Okay. And I think we already know we're sort of getting circular here, but the petition, because that's got an affidavit where the investigator's certifying the truth and accuracy of the statements,
Yes.
that we take at face value. Yes?
Yes.
Okay. Then when you're looking at the case notes, correct me if I'm wrong here, to determine whether or not the investigator inserted truthful, honest, accurate, and complete information in the case notes, you go back and compare that with the petition.
Yes.
And that's all you do?
Yes.
Okay. You don't talk to any witnesses?
Witnesses, no.
You don't go and review any witness statements?
I may review the file if there's notes in there.
That's what I'm asking. You don't do any independent investigation to ensure that the reported information is truthful, honest, accurate, and complete?
That's correct.
Okay, we just take the investigator's word for it.
Yes.
Okay. Now, back when you were, before you were an investigator level 4, before you took on some additional supervisory responsibilities, was the system more or less the same as what you've just described for me, where you would have a supervisor that would review your work before it went to court?
Yes.
And at level 4, who was your supervisor?
Lynn Hart?
Okay. So between August 2014 and April 2015, was Lynn Hart your supervisor that entire period of time?
Yes.
Okay. So she would have been the one that was reviewing your court reports to make sure they were truthful, honest, accurate, and complete, correct?
Yes.
Okay. So for the moment, let's just talk about when there's a court case, just to make sure I understand here. At the outset of the court case, there's going to be a petition filed and a preliminary protective hearing report filed with the court, correct?
Yes.
Explain that process to me. Do they come in together, separate times? How does that work?
Separate.
Which comes first?
The petition.
And I think you told me this earlier, but that's something that's filed by the Attorney General's office with an affidavit regarding the truth and accuracy of the factual statements.
No.
Okay, explain to me what we're talking about there then.
You fill out the petition. You submit it to the Attorney General's office. They review it, add their allegations. They send it back to you to review and correct if necessary. And if it's correct and no changes need to be made, then you sign the affidavit.
Okay. Okay, and then how long after that petition is filed, how long until the preliminary protective hearing report is supposed to be filed? If you know.
I can't give you an exact.
Sure, an estimate's fine.
About a week.
Now that preliminary protective hearing report, that report is not reviewed by the Attorney General, correct?
Reviewed? No.
Okay. What happens there is the investigator puts together, drafts the report, then the supervisor will look at it to ensure its accuracy and that
Yes.
the form is correct. Yes?
Yes.
Okay. Then do the supervisors then also sign the report?
Yes.
What's the purpose of the supervisor signing the report, if you know?
I'm going to say accuracy and correct format, and that all the allegations are included in the report that are in the petition.
Okay. Is that to let the judge know that a supervisor's actually looked at this report, reviewed it for accuracy and correctness, and actually signed off on it?
Yes.
I'm sorry, your answer was?
Yes.
When you elevated between the different classifications, and we'll talk about the supervisory position a little bit separately, but when you elevated, from level 1 to 2 to 3 to 4, did you have any additional training that you undertook as part of that process of changing job titles?
Only when you got to position 4.
Okay. When you're going to pick up some supervisory duties?
Yes.
Did you ever have any training regarding how to fill out court reports? What's
Yes.
supposed to go in?
Yes.
And in part of that training, did they teach you about, I presume, how to investigate an allegation?
Yes.
Okay. Explain to me how the process works here in Arizona. You get a call to a suspected child abuse registry or hotline or something like that, right?
The hotline?
The hotline. What do you guys call it? Just the hotline?
Yes.
Okay. Who typically can call into that hotline?
Anybody.
Okay. So like a disgruntled neighbor, a parent in a hot custody dispute, a school teacher, those sorts of people can call in?
Anybody can.
Anybody. What happens when a call comes in, who picks it up?
You mean physically picks up the phone?
Well, yeah, somebody takes a report, right?
Yes.
Is that a department?
The Department of Child Safety.
Is it a special division within the department?
Yes.
Okay, what's it called?
Hotline.
And the hotline department, that's staffed with its own people, right?
Yes.
Have you ever worked in that department?
No.
Okay. As part of your core training, did you learn the process about how a call comes in, it's taken, something happens with it, a report maybe gets generated? Did you learn about that process?
Yes.
Okay, why don't you go ahead and lay that process out for me? That's what I'm really looking for here, is to understand how an investigative case would get to someone like you from the hotline to the point where you pick up the investigation. How does that process work?
So anybody can call the hotline. It's answered by a hotline specialist. That person takes the information, I believe puts it in the computer. I'm not sure I can outline all of their steps.
Just the ones you recall, that's fine.
They put the information in the computer. It is reviewed by a person higher than them, and they determine the level of response that it will get. Then based on the address, it is sent to the field.
Okay, when you said I'll just call it narrative for lack of a better word, the narrative that the hotline specialist takes down from whoever's calling. You said that gets reviewed by a supervisor and they assign a level of response?
Yes.
Did I get that right?
Yes.
What are you talking about there where you say they assign a level of response?
It's classified as a P1, a P2, P3, or P4.
Okay. P doesn't mean much to me. Is there some significance to each of these levels?
Priority.
Priority, okay. What does priority 1 mean?
It means that you need to respond within 2 hours.
So that's like an emergency response. We need to get out there right now.
Yes.
Okay. Okay, what about P2?
You have 48 hours to respond?
Okay, so that one's not quite so emergent. You've got a couple days to figure it out and get out there.
Yes.
Okay. How about P3?
72 hours?
Same with respect to a P3. It's not quite such an emergency situation as a P1 or P2. We're getting an extra day. We're jumping from 48
Yes.
hours to 72 hours. So you have a
Yes.
little more time to investigate and go out and do something.
Yes.
What about a P4?
You have 7 days.
Okay. Now these time limitations, are those mandatory? So if you get a P1, for example, somebody has to get out there within 2 hours. It's mandatory. Am I correct then that when a priority 1 referral is received, somebody must get out to investigate that within 2 hours? Just based on your training. If you had no such training and you have no basis to answer, then just let me know that. But if you have experience, training, some understanding you developed in the last several years working at the agency about how these priorities work and what's supposed to happen, then I'm entitled to your best estimate.
Am I correct then that when a priority 1 referral is received, somebody must get out to investigate that within 2 hours?
Yes.
Okay. Same with respect to the level 2 and level 3. So with level 2, it must be investigated within 48 hours, level 3 within 72.
You are required to make a concerted effort to meet your response time and contact the family.
Okay. And correct me if I'm wrong, but that concerted effort, is it the same level of effort with respect to one of these priority 1 as it would be to somebody that you've got 7 days to look at?
I'm not sure I understand what you're asking.
Well, if I understood you correctly, and at any point if I misstate what I think you said, anything like that, I don't want to do that. I don't want to put words in your mouth or twist things up or anything like that. I'm really looking to understand how you guys work. So if at any point I say something that's not right, definitely reach over and slap me and correct me and get it moving in the right direction. I don't want to misunderstand anything as we're going through this, but as I understand it, the priority 1 referrals, those are basically emergency referrals. We've got 2 hours, something's really going on there, we got 2 hours to go figure it out, right?
The same answer. You have 2 hours to make appropriate efforts to contact the family or the child. Somebody has to make that response.
Your agency does not have unlimited resources, right?
Correct.
In fact, you have limited resources.
Yes.
In some instances, very limited resources.
Yes.
Has it been your experience over the years that, at least in some instances, there is not enough staff available to go out immediately and investigate all of these referrals as they're coming in?
Can you read it again?
Has it been your experience over the years that at least in some instances there is not enough staff available to go out immediately and investigate all of these referrals as they're coming in?
Yes.
Okay. So correct me if I'm wrong, because again, I don't want to assume anything, but if we have to prioritize between a level 1 priority referral and a level 4 priority referral, recognizing we have limited resources, is there some sort of selection process or triage process that goes on so we can figure out where to devote the resources that we do have in terms of these priority levels?
There is a, as far as I understand it, there is maybe a checklist that the hotline goes through, and it has to meet certain criterias to meet that certain level of response.
Okay, and then the hotline will assign a response and send a referral over to investigations.
Yes.
Okay, is there any intermediate step between that assignment of a priority level and the time that investigations gets the referral?
I'm not sure I understand.
Well, is there another department? Describe for me the process. We get a referral. There's we called it, I think, a screener narrative, or I called it a screener narrative that's created. The supervisor reviews it, assigns a priority level. Am I right so far?
As best as I know, yes.
Okay. Once the supervisor assigns a priority level, what happens with that referral?
Then it is sent to the field with the appropriate zip code, address,
And that's based on where mom lives.
usually.
And when you say sent to the field, is it sent to a investigations unit out somewhere in the field?
A unit, yes.
Okay. And that's what you call them, investigations units?
Yes.
And then what happens with the referral?
It goes into a queue,
Okay.
and then it comes to the supervisors. The supervisors review it and assign it.
Okay. And you're a supervisor now, right?
Yes.
Are you one of those people that would review the incoming referrals and then assign it to somebody for investigations?
Yes.
Is there any sort of, you understand what triage means, right?
Yes.
Is there any sort of triage process that you go through when you've got a bunch of referrals, you have limited resources? Do you go through any sort of process to figure out which ones get priority for investigation?
At times, yes.
Okay, what's that process?
Reading the report and the allegations. If it has a criminal conduct attached to it. And then we read it in triage.
So correct me if I'm wrong, you read through the allegations, and depending on those allegations, the seriousness or severity of the allegations, you might give that particular report a more attention than you might give to a lesser egregious allegation.
Possibly.
Okay. And if there's a criminal element to the alleged conduct, that would factor into your decision-making process. How?
If it has criminal conduct allegations, it may receive a higher triage.
Okay. Similar to what we were just talking about, where, for example, if we have a allegation of child sexual abuse by a caregiver or parent, that might get moved to the top of the stack.
Yes.
And if there's a criminal investigation going hand in hand with that, that might be further impetus to get out there, immediately to sort of move that ahead of everything else.
Yes.
Okay, let's go back now to your core training. I think you already told me in the core training you learned about some investigative techniques, right?
Yes.
You learned about court reports and the sort of information that you're supposed to put in a court report, right?
Yes.
Well, you learned that as an investigator, once you do your investigation, you've got to somehow get that information into court, right?
Yes.
And I presume that you do that through the vehicle of a court report, right?
Yes.
Did they teach you what sorts of information you need to put in those court reports.
Yes.
Okay, what'd they teach you?
Overly broad, go ahead.
Dates, participants, allegations, responses to the allegations, any services you provided, any services that were asked for, a general conclusion, that's about it.
Okay. When we're looking at responses to the allegations, that element of the report, what are you talking about?
Something the children may have said, something the parents may have said, anybody that you interviewed.
As part of the investigation, what you learned in your core training, correct me if I'm wrong, is that the witnesses that you're required to interview in putting together this report as part of your investigation are the victim, the parents, siblings, others who live in the home, and anyone with knowledge of the allegations, correct?
Yes.
And when you say you're required to interview those people, what do you mean?
You're required to at least make an attempt to contact them.
Okay, so you're not necessarily required to actually talk to them, you're just required to try to talk to them.
If they are available, then you should be talking to them.
Okay. Who makes the decision about which witnesses actually need to be spoken with and which ones we just don't have to worry about immediately?
Mostly the investigator.
So it's left to the discretion of the investigator. It's not our supervisor.
It could be both.
Did they teach you that your court report was an official document?
Yes.
You understood that in 2013 and 2014, that your court report was an official document?
Yes.
That it was an official document that would be filed with the court? Yes?
Yes.
That a judge somewhere would be reviewing that official document and making decisions based on the information in it?
Yes.
Okay. And you knew all that from your core training?
Yes.
So all throughout your career, even to today, you understand that?
Yes.
Okay. Were you also trained that for that very reason, because the judge is going to review this and rely on it, for that very reason, it's critical that in their reporting, investigators be truthful, honest, accurate, and complete?
Yes.
You did learn that?
Yes.
Okay. And you understood that in 2013 and 2014?
Yes.
And you understand that today?
Yes.
Do you teach your own subordinates that it's critical that the information they put in their court reports is truthful, honest, accurate, and complete?
Yes.
Okay, why?
You're representing to the court what happened, and it needs to be truthful.
Yeah, because the court's going to make some decisions that may have a very direct, immediate, and long-lasting impact on the child and the family, right?
Absolutely.
So it's critical that the court have honest, complete, accurate information, right?
Yes.
Okay. And that's also part of the reason, isn't it, that the investigator is required, where possible, to make every effort to go out and actually speak with the witnesses so they can get firsthand information, correct?
Yes.
Did you learn anything in your core training about the constitutional rights that run between parents and children? Or actually, let me back up, because maybe they didn't even cover that. At any point in your career with the agency, Have you ever had a training, whether it was core training or some other subsequent training, where the subject matter covered the constitutional rights that run between parents and children, if any?
I don't recall.
So you don't remember, perhaps in your core training, being taught that parents and children have a protected liberty interest in the continued, uninterrupted maintenance of their relationship?
I can't recall.
That doesn't sound familiar to you?
Not in core.
How about in some other training? Not in core implies to me that there may be some other training where that did come up. Why don't you go ahead and tell me about
Possible, yes.
that? Okay, when was that?
And say around the same time as core, maybe?
So like 2010-ish?
Yes.
Okay. And you have this vague recollection that you had this training about the rights that run between parents and children. You just don't remember specifics.
Correct.
Okay. Why don't you give me generally what you do remember? What are the rights that run between parents and children?
Between parents and children?
Mm-hmm. Yes.
I don't know that I can answer that.
Okay. Have you had any training within the last, let's just say from 2014 forward, have you had any training that you recall that addressed this issue, the constitutional rights that run between parents and children?
No.
So I just want to make sure I've got this clear and correct. The only training that you vaguely remember that might have touched on the issue of the constitutional rights that run between parents and children was back in 2010, right?
Yeah.
And you don't remember the specifics of that training?
No.
You also don't remember the rights, anything about the rights that run between parents and children?
Correct.
Okay. Have you ever been trained, and when I ask this question, have you ever been trained, I mean from core training all the way through today, have you ever been trained that a warrant or court order is required if we're going to remove a child from the custody of its parents in non-emergency circumstances? Do you understand the question?
Mm-mm. No.
Okay. Do you know what imminent danger means?
Yes.
Okay. What does that mean?
The child is at immediate risk of harm.
What kind of harm?
You have to form, Beg, go ahead.
Do you understand what I'm talking about when I say what kind of harm?
Not specifically, no.
Okay. For example, my kids, they fight a lot. They argue, they do things. And, you know, my daughter might push my son down and he gets a scraped knee. So he's got some harm. His knee is scraped. Is that the type of harm that you're talking about when we're talking about imminent danger, a scraped knee?
Not usually, no.
Okay. But you understand the context of the question, right? When we're talking about harm, there's a continuum somewhere between, you know, low-level scraped knee and a child that's being sexually abused, right?
Yes.
Okay. So my question is, on that continuum between the low-level scraped knee and the sex abuse, is there some cutoff there that comes into play when we're talking about imminent danger of harm?
Every case is different.
Okay. So the child with the scraped knee, he could be in imminent danger.
He could, depending on how it happened.
Okay, his sister pushed him off his skateboard.
Not in that aspect, no.
Okay, how do we go about determining, based on your training, how do we go about determining whether or not that scraped knee is sufficient to classify this child as being in imminent danger and risk of harm?
There's a lot of factors that play into it.
Give me some of them. It's certainly not just your gut feeling, right?
No.
Okay, well, let's hear some of the factors.
If a child told you that mom or dad may have pushed them down during an argument, depending on the situation, that might rise to the level.
Does it matter when this argument happened? Like, for example, argument happened 3 weeks ago. Child tells you, 3 weeks ago, mom and dad had an argument, and I got pushed down, scraped my knee. Does the timing matter in your analysis about whether or not now, when you're out at the home investigating, the child's in imminent danger or risk of harm?
It varies. There could be other things that are going on that day or that time that you take into account.
Like what sorts of other things?
Like maybe the arguing's continued. Maybe there's new allegations. Maybe the child has new injuries. It just varies so much.
Have you ever been taught in any of your trainings from core to today that in order to remove a child from the custody of its parents, you must have reasonable and articulable evidence to show that the child is in immediate danger of sustaining severe bodily injury or death in the time it would take to obtain a warrant? Have you ever been taught that or anything like it?
In obtaining a warrant,
Can I have the question reread, please?
Have you ever been taught in any of your trainings from core to today that in order to remove a child from the custody of its parents, you must have reasonable and articulable evidence to show the child is in immediate danger of sustaining severe bodily injury or death in the time it would take to obtain a warrant? Have you ever been taught that or anything like it?
to obtain a warrant, no.
Have you ever yourself in your entire career with the state of Arizona sought a warrant to
No.
remove a child?
No.
So I guess it would follow then that you've never obtained one either, right?
Correct.
Has anybody ever instructed you, whether it be a supervisor, a trainer, a teacher at one of these courses that you took, has anybody ever advised you that it is impermissible to remove a child from the custody of its parents unless there is evidence to suggest that child is in immediate danger of sustaining severe bodily injury or death?
Can you repeat the question?
Has anybody ever instructed you, whether it be a supervisor, a trainer, a teacher, at one of these courses that you took, has anybody ever advised you that it is impermissible to remove a child from the custody of its parents unless there is evidence to suggest that child is in immediate danger of sustaining severe bodily injury or death?
Yes.
Okay, when did that happen? The training. You're referencing some training, right? When was that training?
During core?
During core. And what did they teach you during core about how it's impermissible to remove a child from the custody of its parents without getting a warrant unless the child's in immediate danger of suffering severe bodily injury or death? What did they teach you?
I'm not sure I understand what impermissible means.
Well, you can't do it.
Okay.
You can't do it without a warrant. You can't remove a child without a warrant unless you've got evidence to show that child is likely to suffer severe bodily injury or death in the time it would take you to get a warrant. That's what I mean.
Can you rephrase the question?
I'm not really sure how I can. I mean, you've already told me that in your core training you learned something about this concept, right?
Yes.
Okay. What did you learn?
We don't obtain warrants.
You don't obtain warrants. And they specifically told you that in your core training? You guys don't need to obtain warrants?
Correct. We do not obtain warrants.
Okay. Did they tell you that anywhere else other than core training?
Standard practice in our department, we do not obtain warrants.
What do you mean standard? You mean it's standard practice in your department not to obtain warrants?
Yes, we do not obtain warrants.
And what do you mean when you say standard practice?
I'm not aware of any time any caseworker has ever got a warrant to remove a child.
And as a supervisor now, you've never told your subordinates that, hey, you guys, or some words to the effect, hey, you guys, we need to get a warrant to remove these kids unless they're in immediate danger of sustaining severe bodily injury or death. You yourself have never told your subordinates that.
Correct.
And one of the reasons that you've never told your subordinates that is because as a matter of practice and policy in your agency, your position is you don't need a warrant, right?
No, we do not need a warrant.
Okay, ever.
Not that I'm aware of.
Okay. Just make sure I'm clear on this, because when I say ever, yeah, I agree, that's a little bit broad. Might even be vague and ambiguous. I'm not sure I understood it. Let me just clear it up. Am I correct that, at least with respect to your understanding as a supervisor within the agency, there are no circumstances under which one of your investigators would ever need to get a warrant to remove a child from the custody of its parents?
Not that I'm aware of.
Okay, so I'm correct in that statement.
That we do not obtain a warrant.
Can I have the question reread, please?
Am I correct that at least with respect to your understanding as a supervisor within the agency, there are no circumstances under which one of your investigators would ever need to get a warrant to remove a child from the custody of its parents?
Is that a correct statement?
Yes, not that I'm aware of.
Okay. You guys mind if we take a quick break? I've been sort of plowing
Okay.
through these. And we talked about this a little bit earlier, but that court report, that's a document that it's important that it's truthful, honest, accurate, and complete, because it's going to get filed with the court, and a judge is going to rely on it in making decisions.
Yes.
Okay. The information in the CSRA does not itself get filed with the court, right? You don't like run a report from CSRA and file that with the court.
That's correct.
Am I correct then that it is also, for the same reasons, it is also critically important that the information the investigator inserts into the CSRA case notes is also truthful, honest, accurate, and complete?
Yes.
Okay. And when we say complete, what does that mean?
I'm not sure I understand what you're asking.
Okay. you just testified that it's important, in fact critically important, that the investigator insert into their case notes information that's truthful, honest, accurate, and complete. Okay, we just talked about that. What I'm wondering is, in your concept, what do we mean when we say it has to be complete?
For investigations, it is the information that you have at the time.
Information you have at the time. That's all information that you have at the time, right?
Yes,
We can't leave things out.
correct.
We can't cherry pick. You know what cherry pick means, right? Okay, we file a petition. That's done by the AG's office after the investigating worker signs the affidavit, right? That's the petition.
Can you reread that?
Okay, so we file a petition. That's done by the AG's office after the investigative worker signs the affidavit, right? That's the petition.
The petition is drafted, it goes to the AG reviews it, adds the allegations to it, comes back, the case manager reads it, corrects it if necessary. If there are no changes needed, then it is signed with a verification with an affidavit.
You said the case manager reads it and corrects it? Is that the same person as the investigator?
Yes,
Okay.
sorry.
So the investigator who's been assigned the case reads it, reviews it, if changes or corrections are needed, makes those changes and corrections, then signs the affidavit.
Yes,
Okay. Then the same person, the investigator, drafts up their initial report, right? What do we call that thing? Their preliminary protective hearing report.
yes,
Okay. Those get filed with the court to open a court case, right?
to open a court case, no.
Okay, well, do you at least have to file the petition to open a court case?
The petition opens the court case.
Okay, and then some point after the petition, you file the preliminary protective hearing report.
Yes,
That's done by the same person, the investigator.
yes,
Okay. Does the investigator then actually go and appear in court?
yes,
Okay. And depending on what the court does, an ongoing worker may or may not get assigned to the case. Is that right?
if you're depending on the court, yes, that could be possible.
Okay, so for example, in a case that gets dismissed, say the court says, yeah, there's nothing here, dismiss the case. We wouldn't get an ongoing worker because the case is dismissed, right?
Correct,
And it'd just be over.
yes,
Okay. If the court says, oh, yeah, hey, there's something here, we need to investigate further, have a full hearing, and perhaps a trial, in that circumstance, would you get an ongoing worker?
yes,
And presumably, when they're reading the case notes and the CSRA, the ongoing workers are going to rely on what's there to also be truthful, honest, accurate, and complete, correct?
yes,
Okay. So for the same reason as with respect to the court reports, isn't it also critically important that the information contained in the CSRA and the case notes, both of those, is truthful, honest, accurate, and complete?
I can't answer that whole question.
So it's okay if some of it's not truthful, honest, accurate, or complete? I don't understand. Where are you having trouble? Why can't you
Complete.
answer? Okay. The CSRA is a summary. It may not be complete, right?
Not only the CSRA, however, your entire file may not be complete because throughout the case, you are still getting stuff from maybe providers, maybe additional police reports. So I can't tell you that a case is complete at this point because you are still always gathering information.
Okay, but at a finite point in time, based on the information the investigator knows at that point in time, the data in the case notes should be truthful, honest, accurate, and complete. We're not talking about stuff coming in a week or two from now. We're talking about at a cutoff point in time. Should be complete, shouldn't it? Everything that you know as an investigator should be there at that point in time.
Should be in there? Yes.
Okay. And part of the reason it should be in there is so that people that come onto the case later, after perhaps the investigator is no longer involved in the case, they're going to go back and they're going to look at those case notes and rely on those case notes.
There's many factors of that.
Let me try this. Back in your core training, that 12 to 16 weeks of core training that you had, did they have any session in the training that related to the case notes?
Yes.
In that session that related to case notes, did they teach you that workers that came onto a case after the initial worker would be reviewing those case notes for information about the case?
Yes.
Okay. And part of that training, they told you that those ongoing workers and people that come later that are reviewing the case notes in the case, they're going to rely on the information in those case notes to be true.
Yes.
And complete.
Yes.
And that's why we're supposed to put everything in there at the time we know it. Did you understand that last question, ma'am?
I believe so.
Okay. Can you go ahead and give me an answer?
Everything that you know at that point should go into your CSRA. However, you may have information that you may not have a hard copy of yet that still needs to go into your file, but you have that information.
And that would go into the case notes, not necessarily the CSRA.
It depends. If your case is still open and you have not had your CSRA approved by a supervisor, you can still add it to the CSRA. If it comes in after, for lack of a better term, I want to say that the case is locked down because it's been approved, then it would go into a case note.
But if we're looking at both data sets together, the CSRA and the case notes, taking them as a whole, we should see complete information.
As long as it was available to the investigator.
At that time.
At that time.
Right. Okay. Have you ever heard the term exculpatory information?
Yes.
In what context?
Court.
In the context of your training regarding court reports?
I'm not sure it was in regards to specifically a court report.
Okay. In the context of your training, whether it be core training or any training that you've had with the agency, have you received any training about any obligations that you may have in relation to exculpatory evidence or exculpatory information?
Go ahead and answer.
Can you define exculpatory?
Oh, let me ask, do you know, as you sit here today, what the word exculpatory means?
I can't say that I do, for sure.
Okay. Do you have an inkling, an idea, an estimation?
No, I'm not going to guess.
Okay. So you couldn't even give me a shot at it without guessing?
No, not at this point.
Okay. What do you call information that would undermine the allegations in a petition that you would file? What would you call that type of information?
I'm not sure I understand the question.
Do you know what exonerate means?
Yes.
Okay, what does that mean to you?
It means some information was provided to find the facts not true.
Okay. And what would you call information that would cast doubt on, not necessarily show that they weren't true, but cast doubt on the truth or veracity of certain facts. What would you call that information?
I don't know that I have a name for it.
Okay. Have you ever been trained by the agency that you have an obligation in the context of your reporting to the court to not just provide the court the information that would show the allegations to be true, but also to provide the information that would undermine the truth of the allegations?
You are to provide the court with the facts of the case, along with the other information that you have.
Okay, so just to make sure I understand, when we're talking about being complete in your reporting, that would include both the information you've discovered that supports the allegations and the information that would show the allegations are not true. You're required to provide both of those elements to the court.
Yes.
Okay.